498 under IPC. Its important facets, and we'll be dealing with certain case laws, and we'll see the best way forward to deal with such situations. Later, it will be followed by Q&A session where the attendees can ask their queries to the speaker, and the same will be addressed by the speaker. And you can ask your queries by writing them down in a Q&A tab. So today, as a guest speaker, we have with us Ms. Megha ma'am. She is a partner at Advocate Clause. Also, she is enrolled with Bar Council of Karnataka. So we welcome you, ma'am, and it's a pleasure to have you on our webinar, ma'am.
Thank you, Anu. Am I audible to everyone? Because when Anu was speaking, the voice was, we were losing, the voice was cracking. I hope I am audible to everybody here. Please do let me know in the chat box. Okay, yeah, so I am audible. Yeah, so very good afternoon to everyone. So today the topic that I will be speaking on is 498A. Now, as you all know, 498A, not only to the lawyers, obviously, when you are a lawyer, you are aware of all the sections in IPC, CRPC and all that. But a lot of non-lawyers I have seen, common people who do not have legal knowledge, but there are few sections in IPC that I think everybody in India is aware of, like 302, 420 and 498A. So the impact that 498A brings in lives of the Indian population is too much. So that's why I think that everybody is aware of this particular section. So I'll just quickly share my screen with you. Okay, I'll just give you an overview of what I'll be basically dealing with in today's seminar. So what we'll do is we'll start with the introduction of the statute, the historical context, why this 498A was brought into picture, then development around it, because it was as soon as the amendment was brought into, it was challenged. It was said that it is not it's not a constitutional amendment. It is contrary to the law. So it was challenged in the courts, and then we'll go on to the landmark judgments, and then I'll open the floor to any question and answers, because I'm sure that this is one particular topic in which a lot of people would be having questions, and the purpose of this seminar is to basically clarify the queries as far as I can of all the participants. And then obviously we'll dive into the case laws. Now coming to the amendment, this particular section of 498A was introduced in the Indian Penal Code in the year 1983, well, to be precise, on 26th of December 1983, by the Criminal Law Second Amendment Act of 1983. This one particular chapter of Chapter 20A was introduced, which had only one section, which is 498A, and the heading of the chapter is of cruelty by husband or relatives of husband. Now, in terms of language, 498A is very clear, very simple. It says that husband or relative of husband of a woman, subjecting her to cruelty. So wherever husband or relative of the husband of a woman is subjecting the woman to cruelty, then that person should be punished with imprisonment for a term which may extend to 3 years, and then fine also. Now in the section itself, the word cruelty also has been, it has been given meaning in the section itself. So there are two clauses, A and B. In A clause, it says that any willful conduct which is of a nature as is likely to drive the woman to commit suicide. So the conduct of husband or conduct of the relatives of husband, if it is of such a nature that it drives the woman to commit suicide or to cause a grave injury or danger to her life or limb or health, then that will amount to cruelty. Then the next section, which is, I think, more interesting one, it says that harassment of a woman where such harassment is with a view to coercing her or any person related to her to meet any unlawful demand for any property or valuable security. So basically, this particular explanation is in regard to dowry demand, right? So these are the two explanations which have been given in the section itself. But as we know that, the concept of cruelty has been, this particular term cruelty has been explained, has been interpreted by the courts in various cases. Some of the very famous landmark cases is in the Supreme Court. It was Dastane versus Dastane, in which I'll just read out the interpretation that the Honorable Supreme Court held. It says it has to be ascertained that whether the conduct charged as cruelty is of such a character as to cause in the mind of the petitioner, that is the wife, a reasonable apprehension that it will be harmful or injurious for him to live with the respondent. It is not necessary, as under the English law, that the cruelty must be of such a character as to cause danger to life, limb, or health, or to give rise to a reasonable apprehension of such a danger. Clearly, danger to life, limb, or health, or it was considered to be cruelty. Then we have a very very important judgment which was pronounced by the Honorable Supreme Court on 19th of November 1993 in V. Bhagat versus D. Bhagat. Very interestingly, in this particular case, mental cruelty. So when we talk about cruelty, it is not only physical cruelty. You are, not only inflicting injury physically to the wife, to the woman, but even mental cruelty was held to be included when we are talking about Section 498A. Again, on 31st of March 1999, the Honorable Supreme Court, in the case of S. Hanumantrao versus S. Ramani, interpreted this word of cruelty in context with the provision of Section 13 in Hindu Marriage Act 1955. Again, the stress here was laid on the concept of mental cruelty, that mental agony or mental suffering is also included when we talk about 498A. Now, as I said that when this particular section was introduced, the very constitutional validity of this particular section was challenged. In as early as 1986, there was this case of Inder Raj Malik and others versus Sumita Malik. Now, a very interesting point was raised in this particular case. In this case, it was held that Dowry Prohibition Act of 1961 was always there, right? So it said that because there is the Dowry Prohibition Act is also there, which deals in similar type of cases. Therefore, introduction of this particular section is ultra vires the Article 14 and Article 22 of the Constitution, and it also leads to double jeopardy. This particular point was raised in, but the Delhi High Court said that no, this particular situation is not an example of double jeopardy, because 498A is very, very different from Section 4 of the Dowry Prohibition Act. Because when we talk about Section 4 of the Dowry Prohibition Act, there only, what we say, a mere demand of dowry is punishable. And the existence of element of cruelty is not necessary. That is what the Honorable Delhi High Court held, that mere demand will be included under Section 4 of the Dowry Prohibition Act, whereas in 498A, the element of cruelty is very, very important. So it punishes such demands of property or valuable security from the wife or her relatives as coupled with cruelty. So this particular argument that this section is actually giving rise to a situation for double jeopardy, it was set aside. It was held by the Delhi High Court that no, this is not a situation of not an example of situation of double jeopardy. Again, there have been a lot of cases wherein the constitutional validity of this particular section has been challenged. In Sushil Kumar Sharma versus Union of India, the issue was raised that 498A should be declared as unconstitutional. And the petitioner there contended that there is a requirement of strict action against those women who are involved in filing frivolous cases against their husbands. So this was a contention that was raised in this particular case. Now, what very interestingly, Supreme Court held, that no, first of all, 498A is not unconstitutional and it is not ultra vires the Constitution. It is very much a valid section. And Supreme Court also held that the object of Section 498A is to curb the menace of dowry deaths, and it cannot be struck down. And Supreme Court said that, it is upon the legislature to legislate. Until the mechanism is devised to control the frivolous filing of cases, we cannot do anything. So this is what the Honorable Supreme Court has held in this particular case. Now, I know there are a lot of confusion. There are a lot of reservations when it comes to 498A, and we have seen cases like Arnesh Kumar Behra and Rakesh Sharma judgment, wherein the Supreme Court has gone to an extent of using words like legal terrorism when it comes to 498A. So it is important to I'll also bring in the Law Commission report. There was this 237th Law Commission report, which said that, first of all, this 498A, it is a non-compoundable offense, it is a cognizable offense, and a non-bailable offense. So in the 237th report, actually it came from this particular case of Ram Gopal and another versus state of MP and another, in which Supreme Court requested the Law Commission and the Government of India that at least make this particular section compoundable, because right now it is non-compoundable. So there was a suggestion by Supreme Court that this particular section should be made compoundable, because later I'll also deal with the National Crime Bureau data, in which you'll see that out of 100 cases of 498A that are filed, the conviction rate is quite low. And why the conviction rate is low? Because a lot of these cases, they end up in some kind of settlement between the parties, and wherein the parties want to settle the case, because this section is non-compoundable, then it's difficult for the parties they have to go to the High Court and all that. So in 237th National Law Commission report, it was a very comprehensible report about it. It also gave a finding that yes, this section should be compoundable and all that, but obviously that has not been implemented as of now. Then again, in the 243rd Law Commission report, the point was highlighted that the amendment in IPC, when originally 498A was introduced, the amendment was brought in to curb the dowry cases, and it was brought in to curb the cruelty against women. So there is no possible way that we can reevaluate the misuse of 498A, because this particular section was basically brought in to protect the rights of women. So there is absolutely no way that we can, reevaluate the issue of misuse of 498A. But interestingly, what this report focused on was that the police officials, when they are exercising their powers under, in case of cognizable cases, they should exercise their powers very, very cautiously, especially when it comes to 498A. And in this context, Section 41 and Section 41A of the Criminal Procedure Code of 1973, the directions under that should be followed. And in terms of this particular Law Commission report, they did not say that this particular section is being misused or not being misused. Rather, the focus of this particular report was on the it gave emphasis to concentrate on the solution, and the solution is that the powers of police under Section 41 and 41A of CRPC. So the directions under Section 41 and 41A of CRPC should be followed. Now, when we come to the National Crime Bureau, National Crime Records Bureau, now every year, National Crime Records Bureau, they release their report of crimes all over India, whether it is crime against women, I mean all types of crime, they release their data. So the report that was released in December 2019, which was in connection to the crimes that were committed in the country in the year of 2018. I would just like to read out the portion of crime against women. It's a very detailed report. If you are interested, please go to the website of National Crime Records Bureau and you can access the report of 2018. In this report, it said that majority of cases under crime against women, out of total IPC crimes against women, the number one head is cruelty by husband or his relatives, which account for 31.9% of the total crime, which is followed by assault on women with intent to outrage her modesty, which is 27.6%. Then we have the third number is kidnapping and abduction of women, which is 22.5%. Then rape, which is 10.3%. And the crime rate per lakh women population is 58.8 in 2018 in comparison with a rate of 57.9 in 2017. So see, we have the yearly statistics which says that when we talk about crime against women, the highest recorded crime is the crime of cruelty on women by the husband or the relatives. Also in this context, I would like to share with you, if I'm able to, there is this data about, I don't know if I'm able to share that report with you. Okay, I don't think I'll be able to do that. So there is this report of, National Crime Bureau. In this, there is table number 3A.7, which deals with court disposal of crime against women. In this, if you look at the yeah.
Yes, you can share your screen by minimizing your PPT so that you would be able to see your screen.
Oh, is it okay? I'll just try if I can. Yeah, okay. Yeah, I can share. See, yeah. So this is a particular table. It says court disposal of crime against women, and if you look at point number 7, cruelty by husband or his relatives, the cases compounded or compromised, it says 9,693, cases disposed of by plea bargaining 807, cases that were quashed by the High Court is 1190, and then we have cases disposed of without trial. Now this again, the cases are disposed of without trial. Now this can be whether the parties have compromised, and probably there was a compromise, there was a compromise petition which was filed under 482 in the High Court. So it says 11,931. So what I want to, the point that I want to bring out here is that yes, the conviction rate in 498A cases is fairly low. Now, it doesn't mean that the rate is low because all the cases that are being filed are false cases. According to me, the conviction rate is low because of a number of reasons. One important, very important reason is that at some point of time in the litigation, the parties they decide to settle the case. In fact, when I was preparing for this particular seminar, I was going through the Supreme Court website and I was browsing through judgments passed by the Honorable Supreme Court in the year 2020 and 2019. Obviously, that's a very very low sample size for me to come to any conclusion, but I'm continuing my research in this particular area. So whatever cases I came across in 2018 and 2019 under this particular provision of 498A, out of, say, for example, if there were 20 cases, 18 of those cases were actually disposed of because the parties have come to a compromise. The parties have decided to put an end to the litigation and they have compromised. So the conviction rate is very low. Automatically it will be low because the parties are compromising and then there is no need for a full trial in the case. So that is one reason. In fact, that is the most important reason why the conviction rate is low. Now, again, in recent years, there's a lot of debate around the fact that this particular provision, which was introduced to be a shield for the women, is it being used as a sword against their husbands and their family members? In fact, let's again go to the case laws, right? There are case laws, landmark judgments, which we can say. Sushil Kumar Sharma versus Union of India and others in 2005. Then we have Preeti Gupta and another versus State of Jharkhand and another. And this list is actually, this list goes on and on and on, wherein the Supreme Court has used words like legal terrorism. And then, of course, the Supreme Court has recognized the fact that, yes, women are maybe filing frivolous cases, or a lot of 498A cases are actually, are not true. So this has been, using the word legal terrorism, that in itself proves that it is quite grave, right? Because this kind of terminology, that also used by the Honorable Supreme Court. So then, in a lot of cases, like the latest obviously is Arnesh Kumar Behra versus State of Bihar in 2014. So in all these cases, Joginder Kumar versus State of UP and DK Basu and Lalita Kumari, obviously the first three cases were not in connection with 498A, but Arnesh Kumar was definitely in connection with 498A. So the concept of arrest was discussed, that arrest should not be a routine matter when it comes to 498A, and the directions which are there in section 41 and 41A of CRPC, those should be followed by the police officials, especially when it comes to cases of 498A. In fact, in Arnesh Kumar Behra, I'll just quickly read out the directions which were given by Honorable Supreme Court. It says that all the state governments, they need to instruct their police officers not to automatically arrest when a case under section 498A of the IPC is registered, but they should satisfy themselves about the necessity for arrest under the parameters which are laid down in section 41 and 41 A1B2 of CRPC. There is a checklist, containing specified subclauses. Then the police officer shall forward the checklist duly filled and furnished with the reasons and materials which necessitated the arrest, while forwarding or producing the accused before the magistrate for further detention. Then the magistrate will, while authorizing detention of the accused, shall peruse the report furnished by the police officer in terms aforesaid, and only after recording its satisfaction, the magistrate will authorize detention. The decision not to arrest an accused also should be forwarded to the magistrate within 2 weeks from the date of institution of the case, with a copy to the magistrate, which may be extended by the superintendent of police of the district for the reason to be recorded in writing. Then another very interesting provision is there is a notice of appearance in terms of section 41A of CRPC that has to be served to the accused within 2 weeks from the date of institution of the case, and this period can be extended by the superintendent of police of the district for the reasons to be recorded in writing. Now, so the basic concept is that there should not be automatic arrests. The notice of appearance should be given to the accused as per the provisions of section 41A. And if the person is complying with that notice of appearance, so whenever he is being required for investigation in the matter at the police station, if that person is kind of complying with it, then in such cases there is absolutely no reason to arrest that person. In fact, in Arnesh Kumar Behra, the Honorable Supreme Court also added that whatever these directions are given in this particular case shall not only apply to the cases under 498A of IPC or Section 4 of Dowry Prohibition Act, but these directions should be applicable to all the cases where offense is punishable with imprisonment for a term which may not be less than 7 years or which may extend. So where the imprisonment is 7 and below, these directions that have been given by the Honorable Supreme Court and Arnesh Kumar Behra should be complied with. So this was about the directions as far as arrest of a person is considered. Now again, we'll return to a very, very interesting judgment, which was, I think, the most talked about judgment when it comes to Section 498A. Yeah, in Rajesh Sharma versus State of UP 4 AIR 2017 SC 3869, I think this was the most talked about judgment. In this, the Supreme Court gave a very, very detailed guidelines in regard to 498A. It said that family welfare committees have to be formulated. Then there will be a designated investigating officer in the area. Only that person will be investigating the case. Then again, since it's a non-compoundable offense, and even if the parties want to close the case, they have reached a agreement, then also they had to file 482 for quashing with a joint affidavit that we have compromised in the case and all that. So it said that district and sessions judge or any other senior judicial officer could dispose of the proceedings and close the criminal case. And the bail application, if it is filed in a clear day's notice, then the bail application can be decided on the same day. Then impounding of passports or issuance of red corner notice should not be a routine. So because a lot of applications were being filed for impounding of passports. Then again, it said that all the connected cases between the parties arising out of matrimonial disputes. And then also that, personal appearance of especially the relatives of the accused is not at all required. So this was seen by women rights groups as something which took away the basic concept of 498A. See, at the end of the day, 498A is a criminal provision, right? And by this judgment, the very, the very soul of 498A was taken away, because all the power under 498A was taken away. And this was obviously challenged, and then in in the case of a social action forum for Manav Adhikar in 2018, 10 SCC 443. I'll not say it was overturned, but there were some provisions, some guidelines which were given in the Rajesh Kumar judgment that were overturned. So when it comes to a constitution of a family welfare committee, the Honorable Supreme Court said that no, this particular guideline is beyond IPC. So this particular guideline cannot be given in a case of IPC. So that was taken away. Then in terms of arrest, again, the court said that whatever directions are there in DK Basu, in Lalita Kumari, in Arnesh Kumar Behra, all those guidelines should be followed. It is not that there will be no automatic arrest or there will be automatic arrest, but basically all the arrest guidelines that have been given by the Honorable Supreme Court in a number of cases, all those guidelines should be followed. Because in Rajesh Kumar, it was said that not necessarily High Court has to close the case, even District Court can do that. For this, again, the Honorable Supreme Court said no, because it's a non-compoundable offense, then only the concerned High Court has the power to quash the proceedings under 498A. Now, again, as far as the appearance of family members was concerned, it was said that we are not giving any directions as regard to that. The family members are free to file an application under Section 205 or Section 307 of the CRPC, and then that particular application can be decided by the court. So that is the latest on 498A, and that is where 498A stands today. It is such a vast, it is one section which is, I think, invoked in so many litigations that it is very, very difficult to kind of set a benchmark that, okay, this is the procedure, because every case is different. In fact, while I was going through the Supreme Court website and I was browsing through judgments that have been passed in 2020 and 2019 in terms of 498A, as I said before also, a lot of these cases were ending because the parties have reached to some mutual agreement, and they don't want to waste their time in litigation. So they have reached a point where they want to put end to the litigation. But again, I know a lot of things have been said, not only by common public, not only by different lawyers groups, but by the Honorable Supreme Court also, using the word legal terrorism is something very serious, and it was realized that this particular provision is misused. But then again, what I want to pose a question before the audience is that why is it that when we talk about misuse of a particular section, we are focusing on only 498A, that 498A is being misused? Has anybody done a study that for example, a 420 is 420 also misused? So why is there so much unrest about only misuse of 498A? In fact, I would like to share another experience of mine, which recently I recently stumbled upon this particular judgment. So when I was researching for judgments, then usually it is the husband which approaches the court to quash the proceedings, right? Whether it is High Court or whether it is Supreme Court. Now, very surprisingly, I came across a judgment. The cause title of the judgment was the name of a lady versus the particular state. So I was curious that whatever judgments I have researched on till now, the husband is the petitioner. So why is it there is a case in which wife is approaching the Supreme Court? So when I read that particular judgment, I was really surprised, because in that particular, I'll tell you the facts in brief. The facts were that this lady, she got married to her husband in the year 2006. Then from 2006 onwards, they were having clashes, and she filed a complaint also. It was not a registered FIR, but she went ahead and filed a complaint that she is being treated with cruelty, but nothing happened. So then she had two children from the wedlock. Then in the year 2011, she finally went ahead and filed a case of 125 CRPC against her husband for maintenance. It is when she filed. So right now there are no 498A cases, nothing. There is only one 125 CRPC case that is for maintenance, saying that my husband is treating me with cruelty from the last 5 years, and now I'm not in a position to live with him. So maintenance should be granted to me. When she filed this 125 CRPC, that is when husband filed a case under 420 against the wife. The ground that he took under 420 was that she told me that she was doing MCA. She told me that she is MCA at the time of wedding, but the reality is that she was not MCA. She was in the final year of MCA. She had not completed the MCA. So just he took that ground. He actually managed to file a 420 case against the wife. Wife filed a quashing petition before the Honorable High Court of before Allahabad High Court. That 482 was quashed, and finally the lady came to the Honorable Supreme Court, and she said that it is only as a counter blast because I filed a 125 CRPC, and that is when my husband filed this particular case. So in that particular judgment, which is a 2020 judgment, imagine the case. She was married in 2006. She filed a 125 CRPC in 2011, and the 420 that was filed by the husband was again in 2011. In 2020, finally the Honorable Supreme Court said that yes, this is a very classical case of a husband taking revenge on the wife. And the only ground that has been taken in 420 is that she was not MCA. She was doing okay. So I see that somebody is saying that share the 2020 judgment where husband filed section 420 again. Yeah, I'll do that. I'll do that. In fact, so I was quite surprised that this is the kind. So for those who are interested in this particular judgment, it is Anupriya Pal and others versus State of UP. It is Criminal Appeal number 994 of 2018. And this particular judgment is passed on, it's a 2018 judgment, August 13, 2018. And in para number 7, I'll just quickly read out 2 lines. The Honorable Supreme Court has said, this is a classic case of taking revenge by the husband against the wife, since he was aggrieved by the action of the wife, moving an application seeking maintenance. Absolutely no allegation which could fit in the offense under section 420 IPC is found in the first information lodged by the respondent husband, since the first information of respondent appears to be a counterblast to the maintenance proceedings initiated by the wife against her husband. These proceedings are liable to be quashed. So, I mean, this is the contrast. There are cases on one hand wherein the Supreme Court has used the word legal terrorism when it comes to misuse of 498A. But at the same time, even as late as 2018, there are cases wherein the husband has filed a frivolous complaint against the wife, just as a counterblast for the maintenance case that she had filed. So now I'm not judging here that whether 498A is being misused or not, is being used as a sword. It was meant to be a shield. Yes, I understand that there are cases where the allegations made in the first information report were not grievous in nature, or that does not amount to cruelty. And again, every case comes down to its own facts. The whole judgment around that will be very, very case specific. Very a lot of it will depend on the particular facts and circumstances of the case. Like for example, in few cases, when the term cruelty was being interpreted, different courts have held that having illicit relationship outside of marriage is not cruelty. Then again, in a lot of cases, sorry, because there the facts were different. The base fact was, yes, that the husband is having an illicit relationship outside of marriage, but he brought that lady in the house and he was subjecting the wife to cruelty because he was in fact indulging in sexual relationship with that third woman in front of the wife. So in those cases, the Honorable Supreme Court and different high courts have said that yes, it amounts to cruelty. So again, just saying that having illicit relationship does not amount to cruelty, no. In every case has different facts. All will depend on the facts and circumstances of a particular case. Now again, if we look at the journey ahead, what can be the solution of whatever problems people are facing if they are facing a frivolous 498A proceeding, I think the debate should not be around the fact that 498A is being misused or not being misused. The debate should be around the fact that whether the police officials are actually following the guidelines of the Honorable Supreme Court in Arnesh Kumar Behra, and they are following the guidelines as provided in the section 41 and 41A of the CRPC. I think that is the more important question, because if we talk about misuse of laws, in that case, why 498A? Even a 420 can be misused, right? Even 302, I mean, any section for that matter can be misused. So rather than talking about it's being misused, not misused, the main area of focus should be the execution part. If there are any directions which have been given in a law, in a legislature, in CRPC under 441A, then those should be followed. That is, I think, the more important debate. Now, I see a question. Okay, it says, can we say that Domestic Violence Act can also be included under Section 498A? If yes, since emotional cruelty, as you said, is considered, does financial disturbance caused to wife deliberately by husband can also be brought under? See, again, I think you have clubbed 2-3 questions in this. When we talk about DV Act, the reliefs that are given under DV Act are very, very different when we talk about a 498A. Because 498A is penal, there will be a penalty. The result will be imprisonment for 3 years, right? But when we talk about DV, the kind of relief that is under DV is very, very different. And you are saying that emotional cruelty, yes, emotional cruelty, obviously, as I said, not only physical cruelty is looked into, but mental cruelty is also held to be cruelty of equal, grave nature as physical cruelty under 498A. And I don't know what exactly you mean by financial disturbance caused to wife deliberately by husband. But if you want to say that, the husband is not providing or maybe causing problems in your employment, then obviously, again, it will all depend on the facts and circumstances of each case. There cannot be a benchmark formula for all the cases. There are unique facts to each and every case. I understand the plight of people who may have been wrongly implicated in a 498A, and their position nobody can understand, right? But again, please understand that there are cases wherein even husbands have file frivolous cases just as a counterblast to that 498A or a 125 CRPC, as I gave you one example, right? So I think I'll end with that, and I will, open the floor for any question and answers, because I'm sure that a lot of people will be having confusions or a lot of questions regarding to 498A, and I'll try my best to kind of clarify as far as I can, basis my experience. I see Sushil Shankar is raising his hand, I think. Anu, if you want to take it forward from here, yeah.
Yes, yes. Yeah, participants, now since ma'am has said that the forum is open for question and answer session. So either you can write your question in a Q&A box, or you can raise your hand so that I'll unmute you. We have with us, yeah, Sushil Shankar. Please ask your question.
Yeah, can you hear me?
Sushil, please.
Yes, Sushil. Yes, Sushil, we can hear you.
I have a question for you.
Yeah.
It's an actual case. Now, under 498A, case has been filed, but the police are refusing to file a charge sheet for some reason. What are the possible remedies for us?
Police is refusing to file charge sheet, is it?
They are delaying it. I mean, they're dragging it on for the last 10 months. They have not.
Oh, see, that is a very, that's what I'm saying, that, that is a very, very classic case. In fact, here in Bangalore, we have seen cases wherein charge sheets are filed after a period of 1 year, 1.5 years, 2 years. Basically, so obviously, if the case is instituted, there are only two outcomes. Either the police will file FR, which is final report, or B report in some states, as we call it, or they will file a charge sheet. Now, if they are filing a charge sheet, then obviously they have to complete their investigation. So what I am assuming is what the police will say is that they are investigating the case. Until the time their investigation is completed, they cannot file a charge sheet. And as you said, it is 10 months. It's a period of 10 months and they have not filed a charge sheet. What I'm assuming is because we are in a COVID situation, and last 6 months, we have, I mean, no, for that matter, no legal machinery has been able to do any work. So what the police will say is that we are investigating the case. Once we have investigated the case, we have recorded the statements of all the witnesses, only in that case we can file the charge sheet.
Okay, but actually it seems to be something more than that. They seem to be reluctant for some reason.
They are always reluctant. Yes, they are.
I don't want to say corruption, but they're even when the lady concerned is trying to meet the commissioner of police, they are dissuading her from meeting him. So there is some kind of interest involved over there. It's not.
See, again, it's yeah. So it's a very different kind of discussion. I know that you don't want to use this word corruption, and nobody wants to use that corruption. We have very, very honest officers also in our police force. So, let's not go there. But again, I mean, obviously it is being delayed, but the possible response that the police can give of this is that they are investigating until the time they complete their investigation. See, because obviously once the charge sheet is filed, then they have to complete the investigation before filing the charge sheet, right? So probably they are taking this time to investigate the matter, and obviously they will have to file a charge sheet. I see two more questions in the Q&A window. I have a question from Rahul Devmore, which says, when there is already civil remedy available under DV Act for all kinds of cruelty, why separate criminal section for same offenses? Are they not covered under existing IPC sections like causing hurt, etc.? See, Rahul, again, the answer lies in your question itself. You say that already there are civil remedies available under DV. Yes, under DV, there are civil remedies that are available, and especially for the criminal offenses. So that is why this particular section of IPC is there. And then you say that there are existing sections of causing hurt and all that. See, you have to understand that when this particular IPC section was brought into picture in the year 1983, there was a rampant of cases of dowry in India, and uh, you know, so in a normal crime, in say causing hurt, like you have given the example of causing hurt, causing grievous hurt, the person who is causing hurt may not be a family member, and there was a need which was felt that there should be a particular section which deals with offenses when it comes to in-house cruelty, because husband and relatives, the woman is being subjected to cruelty in her own house. So for that, this particular section was brought into picture. And yes, under DV, those are civil remedies. Those are not criminal remedies, right? So that is why this particular section was brought into place. Then we have is not providing something to the wife, which is not the basic element required for sustaining life, can be classified as cruelty, like not taking the wife to shopping termed as. I mean, I don't think not taking the wife to shopping will be cruelty, but again, it will come down to the facts and circumstances of each case. I have seen a case wherein the husband is not allowing the wife to step out of the house. Now, if you say that for shopping, no, I mean that you cannot, that will not qualify as cruelty. But if you're not allowing her to even step out of the house, that is wrongful restraint, right? So that obviously will be cruelty. So again, I mean, as I said, there can be no benchmark that this constitutes cruelty or this does not constitute cruelty. It will all depend on the individual facts and circumstances of the case. We have a question from Lalima Das. It is often suggested to the husband or the relatives to apply for anticipatory bail despite the wrong implication of the wife. Is it the correct way to approach the matter? See, we as lawyers, we suggest you to file for an anticipatory bail just because if you have apprehension that you may be arrested by the police, if there is already an FIR that has been registered against you, so that is when we give you advice of filing an anticipatory bail. But not anticipatory bail again is not required in all the cases. There are cases wherein we do not suggest our clients to file for anticipatory bail because that is not required. Only wherein there is an apprehension that the person will be arrested, only in that case we suggest our clients to file for anticipatory bail. And again, whether you will get anticipatory bail or not get anticipatory bail again is a totally different thing, right? Because there are certain courts which certain judges which see that whether there is a prima facie case or not, and if there is no again the very concept of whether there is a prima facie case or not, because at the time of granting anticipatory bail, the court obviously cannot go into the merits of the case. It just has to ascertain that, okay, if this particular person is not arrested, then what will be the harm? Like whether if this person is being called to the police station, will he come to the police station and cooperate in the inquiry, or this particular person will not abscond? Or very important thing is that if the person is out, then whether that person will try to tamper with witnesses or the evidence. So that is what is looked into. But again, anticipatory bail, yes, you can file anticipatory bail if you have an apprehension that you may be arrested by police and there is already an FIR registered. But in other cases, you do not need an anticipatory bail. Again, I think we have a question. If the husband is MD of the company and wife files sexual harassment under POSH while their divorce is pending, can such matter fall under section 498A? So see, POSH again, is the wife living, is the wife working in the same company as the husband? Because sexual harassment at workplace, I don't know. I mean, if they are working at the same place, then I don't know how that will play out. Again, it is very, very, uh, uh, it all comes down to the facts and circumstances of a particular case. But yes, if the wife is filing for a 498A and she knows that already there are proceedings against you, she will definitely report that to the police. She will definitely put that in the complaint. She will, yes, she will. That now, if you ask me whether that will fall under 498A, is again, the court will have to take a decision whether whether this amounts to cruelty or not. Because again, if you are saying sexual harassment at workplace, then whether those charges are proved against you or not, then that is altogether a different story, right? So maybe you are acquitted of your sexual harassment charges in your this thing at workplace. In that you are acquitted. Then it cannot be part of your 498A, right? Again, Rahul has asked, should not husband be also have such IPC provision to get relief against wife for cruelty faced by husband and make this section gender neutral? See, Rahul, when you talk about Article 14, um, yes, equality for all, right? But there are, so Constitution empowers the government to make special provisions for a particular class, like women, SC/ST, children. So women, they have been recognized as a different class. So here is a class of people who were oppressed for a number of years, right? So that is why special provisions are being made for women, because they in itself class, they qualify as a class. That is why this particular provision has been. Now, as far as you talk about gender neutral, now again, I don't know whether we as a society have reached a place wherein it is right time to start framing gender neutral laws, or do we actually want gender neutral laws? Again, it's a matter of a very different debate. As a society, have we reached that point now or not? Ways to fight an erroneous case filed by the wife under 498A. Again, Lalima, it will all come down to the facts and circumstances of your case. When you say erroneous case, why do you think that it is an erroneous case? So you have to convince the court that it is an erroneous case. And if there is truth, definitely truth will prevail and you will be acquitted of that particular offense. So again, I mean, I cannot say that this is the prescribed formula. You do step number 1, step number 2, step number 3, or you go ahead and file some frivolous case against your wife so that she will be under pressure to kind of take her case back. No, I mean, I don't think there is a benchmark formula which I can say that you do as a counterblast, because again, as you have seen, that Supreme Court has in very stringent terms criticized the counterblast cases which have been filed by husbands. So you have to be very, very cautious in terms of that. Can you share your email ID? So again, Purvi, my law firm is called Advocates Close. So if you will search advocatesclose.com on Google, you will find my law firm. Again, my email ID is megha.jobanputra@advocatesclose.com. You can reach me there, or I'm there on LinkedIn, and my website is there. You can connect to me on my website.
Right.
So I think that's about that. Yeah.
Yes. Yeah. So far, we have taken all the relevant questions, and Yes, ma'am, there's one question from my side. Like, when we talk about adultery, and there is a ground for which one could seek for divorce, like that is also cruelty, right? Under like divorce,
No, no,
when you
no, no, no,
wanted to
no.
seek.
No, no. Cruelty is different, adultery is different. So you have to either
Yeah.
invoke adultery or you have to invoke cruelty. These are two different things.
Yes, but under the divorce, like when a person is committing his adultery,
Hmm.
so like you can seek divorce, like on the ground of cruelty as well, whether it is included or like
No, 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 not really. If you are
no
saying
the
that, so your question is that your husband is indulged into adultery and you want to file for divorce and you want to include cruelty also as one of the grounds, right? So, in a lot of cases, different courts have held that adultery not necessarily it amounts to cruelty. Cruelty is totally different and adultery is cruelty different.
okay,
Adultery is a different ground which is available to you for filing for divorce, and adultery is different, cruelty is different. You cannot club, or if there may be facts wherein he is indulged into adultery also and subjecting you to cruelty, but
okay,
you cannot say that just because he is indulging in adultery, that is cruelty to me. No, that is not the case. Cruelty is very different. The
okay,
facts which will relate to cruelty are very different, and the facts which will relate to adultery are very different.
right. Ma'am, one question we got from Nilava Nandi.
Yeah. List down the steps that is needed to file under section 498A. Again, no steps. If your husband has subjected you to cruelty, be very, very honest. In very simple terms, write down your complaint in chronological order, whatever has happened in your married life, and just report it to the jurisdictional police station. Don't go into legal jargons. Don't think that if you will not use this word in your complaint, then it will be a weak complaint. No, there is nothing like a weak complaint or a strong complaint. uh, you should honestly report the facts, whatever has happened in your married life, in a chronological order to the jurisdictional police station.
Right. So yeah, this was today for the session. So ma'am, like we'll sign off. Before that, I'll ask my participants to rate this particular webinar from 1 to 10, 1 being the very lowest and 10 being the highest.
I think we have one more question.
From
Deepak
Deepak
Kumar,
Kumar.
yeah, he is saying after a marriage, in how many years the wife can file under Section 498? Anytime. There's no in a criminal case there is no time limit. She can file as early as 1 month, and she can file as late as 5 years.
Right. Okay. Yes, we are getting a feedback. Ma'am, could you please, like in the end, could you please throw some light over the international status of this particular, like what we can say, a issue? If you can
See,
please.
yeah. So if we look at it from an international perspective, in that case, what we have to understand is that we cannot compare it with a lot of countries, because the kind of society that we have in India is very much different from, say, a Western society, right? So when it comes to cruelty against women, it is not. I'm not saying that there is no cruelty against women in Western countries. There have been cases where it is even worse than India. But again, it is very difficult to bring in a contrast when it is compared to any foreign country, because the kind of society that we follow here in India is very, very different.
Right, ma'am. We also got a feedback from our attendees, and indeed it was very practical session, I would say. And yes, yes, and we actually got to know the practicality of the session, as earlier you said it that though it is very a small section, but it does have so much of interpretation and case laws, inculcated into it.
Yeah,
So
in
thank you
fact,
so much.
I am continuing my research. Till now, I have only reached 2018 case laws. I am continuing my research, and if any of the audience wants to collaborate with me in that particular research, I would like to do that, because at the end of at least 2021, I want to come up with a comprehensive research paper on the cases of 498A right from 1983 till 2020. So I want to compile a report on that. So if anybody wants to help me in that research, please, you are most welcome in doing that, please.
Right. Yeah. So people can get, connected to, like ma'am has already stated, from where you guys can connect to her. So thank you, ma'am, for joining us, and it was indeed a very wonderful session.
Thank you, Anu. I think Anu got disconnected. Anyways, her voice was quite kind of blurred. So yeah, so thank you, LawSikho, for having me and giving me this opportunity to speak to you people. And thank you, Anu. I think we lost you in between. Anu,
Yes,
are you able to
actually,
hear
there's
me?
some technical issue.
Yeah, I think there is some technical
Yes,
difficulty
ma'am.
at her part. No worries. So thank you, LawSikho, and thank you, Anu, for having me for this. And I wish, I'm happy to collaborate even in future. And my LinkedIn profile, it's Megha Jobanputra. You will search Megha Jobanputra, founder, Advocates Close. I think you will be able to find me on LinkedIn. Prajakta Pawar, right? Yeah. So thank you, people. Thank you for joining in. Thank you for being patient and listening to me.